this legal issue has been hanging out there, but the sentencing is pretty straightforward if we get to that point. The court has a lot of options that know.
Counsel, Mr. Jansen has filed a motion pursuant to 1181 sub 6. I've read the motion as well as the people's opposition. Is anything further you'd like to argue, sir?
Yes, Your Honor.
Please go ahead.
I've had the opportunity to review the people's opposition, and Your Honor, under the Penal Code section 1181,
Okay.
subsection 6, the court has the inherent authority to order that lessers be instituted and to dismiss the greater offense. So in this case, the greater offense would be in count 1, first degree premeditated deliberate murder against Mr. Askedon. The lesser included offense would be voluntary manslaughter. The court can act as a 13th juror, and the court can reduce it to a lesser offense if the court finds that, based on the facts or the evidence, that the lesser was the correct charge, and that, in fact, the jury got it wrong. In order to get to a voluntary manslaughter, which the jury found as to Mr. Lathan and to Mr. Villanueva, they necessarily must have found that there was a provocation and that there was not an adequate cooling off period. In essence, they found that Mr. Holder Jr. acted as an ordinary reasonable person would under the same or similar circumstances. They acted rashly, without deliberation or reflection, and from passion. The jury found that to be true as to Mr. Lathan and Mr. Villanueva. However, they failed to find for Mr. Askedon that there was provocation and a cooling off period. Well, there was only one provocation, there was only one cooling off period, there was only one shooting incident, and so if it was adequate provocation without cooling off period as to Mr. Lathan and Mr. Villanueva, then it must have been an adequate cooling off period, not an adequate cooling off period as to Mr. Askedon. So if we start from the point where the verdicts are inconsistent, then we can get to, well, what can the court do about it? So there's ample authority saying that a jury can reach inconsistent verdicts, that it is within their power to grant inconsistent verdicts. However, it's also within the court's power under 1181 subsection 6 to reduce to a lesser offense. That's what we're asking the court to do in this case. Reduce to the voluntary manslaughter as to count 1. And there was evidence that there was not a cooling off period in the record on this case. Alternatively, we're asking the court to reduce the first degree murder to a second degree murder, which is also within the court's inherent authority under that penal code section. If the evidence in the court's opinion was there was an adequate cooling off period, or that the provocation was not severe enough, the court can still use the provocation, although it's not enough to get it to voluntary manslaughter, to reduce it to second degree murder and find that the premeditated and deliberate allegations were wrongly decided. Thirdly, the defense is asking for a new trial if the court is unwilling to reduce the murder charge to any of the lesser and included offenses, the defense is asking for a new trial on count 1 to be consistent with the evidence and the facts that were presented at the trial. Thank you.
Yes, just briefly in response, because I believe I addressed counsel's contentions in my opposition. The court's power under 1181.6 is based on the court making a finding that the evidence was insufficient to show that the defendant was guilty of the crime for which he was convicted of. The court has the power to then modify a verdict or order a new trial under those circumstances only. The court doesn't have unlimited discretion in ordering a new trial based on the court's own personal assessment of the evidence. In this case, Holder and his moving papers failed to show any deficiency in the evidence supporting the first-degree murder conviction. Specifically, in his moving papers, and I believe in his argument at trial, he conceded the fact that he was in a dispute with Mr. Askedam. He conceded the fact that he was motivated based on that dispute to kill Mr. Askedam. He acknowledged that the evidence showed that the discussion caused him to feel provoked and angry. He conceded that he ruminated on how to respond after being away from the scene for approximately 6 minutes before returning and shooting Mr. Askedam 11 times. In trying to get the jury to accept the theory of voluntary manslaughter, the defense conceded all of those conditions existed. The jury rejected it. They rejected the notion that that discussion, whatever it was, and there was some ambiguity about it, was sufficient to provoke a person into rash impulse and rash actions. They also rejected the notion that even if a person were so inspired that there wasn't enough time for him to cool off before he returned and killed Mr. Askedam. They rejected both. And we know they rejected both from their verdicts, and something that's not in the record, but certainly Mr. Jansen was privy to, was a conversation that we both had with about 6 jurors after they reached their verdict.
That's beyond the court's consideration. That's not part of the record on the part of the record either.
Let me say this, you can argue what you choose. I know what the law is and I'm going to follow it.
Thank you.
And in that discussion, the jury clearly told both of us that they rejected the notion of voluntary manslaughter, provocation, or a lack of cooling off. So the court really has no power under 1181 subsection 6 to modify the verdict in this case, because the evidence is more than sufficient to support the charge that Mr. Holder was convicted of. Now, counsel has also made an argument based on, I guess, a purported doctrine of inconsistent verdicts. And I believe that idea was implanted in his mind when the court said something about it offhand prior to the sentencing hearing today, or this motion today. There is no doctrine of inconsistent verdicts. As outlined in both the U.S. Supreme Court case and the California Supreme Court case that I cited in my opposition. Jurors have the inherent power to reach verdicts so long as those verdicts are based on evidence. They can reach those verdicts in a variety of ways. And because their deliberations are secret, they're outside the purview of the court. The jurors compromise in reaching verdicts all the time. Jurors show compassion and leniency to defendants by convicting them of lesser charges or no charges, even when the evidence is there to support it, all the time. That is a part of the system of justice that we have, and something, frankly, that we can't do anything about. In this case, we don't know whether or not they rejected the people's contention of first-degree attempted murder in lieu of voluntary manslaughter because...
You mean attempted voluntary manslaughter?
Attempted voluntary. We charged attempted murder.
Right.
They rejected that. They chose attempted voluntary manslaughter. We don't know why. We don't know whether it was a product of compromise. We don't know whether it was a product of compassion. It is likely, and there are a number of scenarios that are likely, but one is they recognized the distinction between the killing of Askedam and the shooting of the two others. They likely felt that he was much more culpable in the way that they reached their verdict in the killing of Askedam than in the shooting of the two others. That is a very natural distinction to make based on the evidence. And so there is no doctrine of inconsistent verdicts. Counsel cited no case to support the notion that the court could make any kind of finding based on inconsistent verdicts. The people cited 2 cases to the contrary. So we'd ask the court to deny Mr. Holder's motion today and set the matter for sentencing as soon as possible.
Thank you. Pursuant to the motion that was filed by Mr. Jansen, the court has had the opportunity to independently review the evidence. And the court finds that the evidence presented in this case was of sufficient probative value as to sustain the verdict for, in count 1, the murder of Mr. Askedam, murder in the first degree. The fact that their verdicts as to Mr. Lathan and Mr. Villanueva were, well, there were 2 verdicts as to each, one being attempted voluntary manslaughter and also assault with a firearm. Their reasoning is their reasoning. The fact that it's inconsistent, that happens all the time. So the motion to reduce is denied. The motion for a new trial is denied. Mr. Jansen, you filed a 1050 indicating that you need more time. This matter's been here for sentencing several times. I'm going to allow this last continuance for the sentencing. I just ask that you choose the date wisely, as I'm not going to continue again.
Thank you, Your Honor. I appreciate the time to prepare for the sentencing. I just wanted to correct one thing that counsel said on the record, that the idea of an inconsistent verdict was implanted by the court from an offhand comment that never occurred. I always had the idea of moving for inconsistent verdicts and to make that motion. How about February 22nd, Your Honor? That's okay with the court's calendar and counsel.
Your status, Mr. McKinney, for February 22nd?
The motion to continue will be over the people's objection, but that date does work for me.
All right. I will grant the 1050 over the people's objection. There is good cause. And so, is that date good for us, Gloria, the 22nd?
February 22nd, yes, Your Honor.
All right, it'll be February 22nd. This is probably 8:30 in the morning. Now, sir, you have a right to be sentenced today. You waive that right and agree that your sentencing take place on February 22nd, 2023. Yes, Your Honor. Counsel Jordan?
Yes, Your Honor.
All right, so with that waiver, sentencing will be February 22nd, just upon 8:30 in the morning. We will further continue. Thank you.
Thank you.
Give you some time to cool off, my guy. Got a whole another month to cool off.
Sir, take it outside. I know you can't help yourself,
Cool
but
down
take it out.
here.